Just ask, are we waiting for anyone else to come in on either side? Okay. Mr. Cooper.
Thank you, Mr. President, and members of the tribunal. Just to give you some signposts of where we're going, I'm going to complete this section of the slides in the presentation. I'm going to answer your questions. I'll then hand the podium to Ms. Cohen, and if there's time available after she's finished, I may return to sum up. The slide that I was on, had gone to just before the break, deals with the potential annulment of all the lots. Just with respect to the surrounding facts, and I'll say the significance of them, just to remind you that it's clear on the record that this proposal includes all of the claimants' properties. And secondly, it's clear that it is a consideration which is long overdue, in that it was intended to have a decision made within a brief period of time, and 5 years later we still have no decision, and I gather we're awaiting a report of an independent consultant who we had not known existed before yesterday or day before yesterday. So the other point is, of course, that as I understand, and I read this a couple of times, but I think it's a fair reading of Mr. Jurado's evidence, that this independent report, or this third party, is not the end of the process, but it's actually the beginning of the end of the process. I'm not sure which of the Churchill references are correct there, but that what is intended is that on the receipt of the report, the ministry will then consider whether to decide or consider the decision about whether to annul, and as he indicated, that will be a start. In a sense, the last bullet point, it's difficult to reconcile that evidence in any practical sense with the respondent's lingering effects idea, that these are merely lingering effects. The very present efforts being made by officials are continuing and ongoing breaches, which have not come to an end, and if the claimant's claims are dismissed, clearly there's much to come. If I can say at this point, and I want to return and say something about the state and the state's witnesses in this case, but as respectfully as I can, but let me just say, and all analogies are imperfect and some are dangerous, but my friend called upon the analogy of a train leaving the station in his opening. And in my submission, it is clear that whatever's happening, the train did not leave the station long ago. Whatever analogy, if you stay with the train station analogy, we're probably in a subway, not a train, with trains coming and going and new ones coming and new ones to come. Or you could say we're in this, if we're in a conventional train station, that we have many platforms. Some trains have left. They left at different times during the historical period. Some have left very recently, and some are still in the station that are going to leave at some undefined point in the future. What is very clear in my respectful submission is these are not the types of acts in which time bars are rightly concerned with clearing the decks. These are not ancient disputes. These are not dated disputes. They are essentially fresh and ongoing disputes between the claimants and the state. And perhaps that leads me to my next point, which is, and I recognize that the existence of a right of action to hold a sovereign state responsible for the exercise of its sovereign powers is a heavy responsibility and a serious development in the rule of law. And my clients take that both seriously and are appreciative of it. And let me say equally that I appreciate that agents of the government, and it's not an uncommon observation, find it awkward and difficult and, to some extent, inconsistent with their normal experience to be held accountable in a venue like this for actions which they carry out as agents of the state, which are normally not accountable for except within the domestic legal regime, and in many cases not accountable for at all. Having said that, with respect to the lens, the legal lens that the treaty requires you to apply, in my respectful submission, Ms. Chavez's speech to you, Mr. President, after your question to her, is a vivid and powerful evidence of the determination of the state to take these properties. And her frank hostility to the claimants in respect of their claim to hold the state accountable in this case ought to, in my respectful submission, support that finding of fact on your behalf. We don't often have, if you will, a living expression of that determination. We did in this case. And I understand that, and I'm to some degree sympathetic for it, but in the context of the legal lens in this case, that supports the claimant's claims. Secondly, this case is fundamentally about unconscionable delays. And we know, as lawyers, all systems can, from time to time, fall into either practices, habits, or otherwise in individual cases, circumstances where unconscionable delays occur. That's not the question. The question is what accountability exists for that. The treaty essentially says, if you as a state have engaged in unconscionable delays in the exercise of your state powers in respect of foreign investors, you can be held to account in the practical sense that you can be compelled to compensate the investors in the terms in which you've undertaken to compensate them formally. And it's, of course, a heavy burden on anyone to bring a matter to this tribunal, to an international tribunal. But that opportunity is one fundamentally of driving a just conclusion in accordance with the law, in this context, of the domestic law as well. It simply provides a means by which the state can be accountable for the fundamental obligation of timeliness. At the end of the day, all the claimants are seeking is what they ought to have received within the domestic legal order and that they've been frustrated from obtaining and which they ask for you to obtain. I say to you that Mr. Jurado's evidence is supportive of a conclusion that the state in this record has had a consistent indifference, at the least, to its obligations of timeliness, to process the expropriations without delay, and to act promptly. The new evidence is corroborative of the fact that the historical delays are a product of state action and not a product of happenstance. They're a product of a series of decisions and not a single decision. They are not a product of a lingering error of delay. They're a product of a series of decisions to delay the claimant's receipt of the property value and the compensation that they're accorded and entitled to. And so in some senses, it's unusual to have as vivid a display of a determination to pursue delay, as you have in the Contraloria's report and the ministry's response to it and Mr. Jurado's evidence of where we stand today. And I say that that evidence overwhelmingly supports the conclusion that what you have here is a full support for the necessity and the justice of enforcing the state's solemn promise to act without delay. Now, I think that covers the next two slides. Hopefully it covers them better than the slides themselves. I'll go, if I may, then, to deal with your questions, Mr. President, and then I'll deal with Mr. Cantor's questions. And Dr. Weiler is closer to me now, and so I'm closer to correction, I think is the proper way to put it. So, and I think I've foreshadowed the answers to many, if not all of the questions, but it may be worthwhile. You've asked for sort of deliberative answer period, and so I'll endeavor to try to do that. So commencing with your first question, Mr. President, as I indicated earlier, our answer to it is that it does indeed constitute a separate treaty obligation, and it is not restricted. The legal consequences are not restricted to the original act, whether a direct act or an indirect act. I'm not sure in a logical sense whether there's a binary choice there because we rely upon our pleadings, and I should say in the context of this, of course, we rely on our pleadings on jurisdiction, which of course have a number of arguments and submissions that I haven't repeated here. I think it's perhaps worth saying that there are two respects in a practical sense, at least relevant to this case, in which there is an independent breach. And that is either with the occasion of a delay or delays, or measures which bring about a delay or prolong a delay, but also a subsequent determination of value that is a breach of the treaty. So the series of steps, for example, that lead up to the transfer of title may bring about separate breaches of the treaty during the course of the actual history of a particular event. Those may be compressed into one event. It may happen instantaneously, depending on the circumstances. And of course, the law of expropriation encompasses more than simply real property, and of course that introduces other complexities. So the second question is one which is in relation to the point in which it can be said that the alleged breach in respect of a failure to pay compensation effectively crystallized. And let me say this, and that is, I think that we have to be careful to, in a sense, not transfer terms that are perhaps applicable but not fully appropriate to the circumstances of a delay claim. And let me put it this way. You can use a term like crystallization in a way that presupposes that it's an instantaneous event. And in my submission, in respect of an indirect expropriation, the ongoing nature of the obligations of the state mean that the point at which you can claim an indirect expropriation, I would submit, can more properly be spoken of as a point in which the conditions for a complaint of indirect expropriation have arisen. So it isn't that they crystallize at a point in time. That time will be relevant for valuation purposes. It'll be relevant for all sorts of purposes, but it isn't a frozen moment. We said in our opening that there isn't a frozen moment other than the actual transfer of title moment. But in my submission, what happens in respect of an indirect expropriation is that the complainant has to decide when the facts are sufficient to support the conclusion that the measures taken separately or together are tantamount to expropriation. That's what happens at that point. And so that's the point at which an action for expropriation, if you will, or a complaint about a breach of the obligation of expropriation can be taken. It isn't a point in time.
Before you move on to the third question, may I just ask a clarification? And please don't take this as an indication that, in my mind, anything necessarily turns on this, but just to clarify the point. At various points in your submissions this morning, and I think Dr. Weiler, in his observations on Monday, you've made the point or the suggestion or the contention that there is a sort of a potential delay breach under Article 10.7.1 and then separately under 10.7.2. I'd just like to be clear whether you are alleging or you are submitting that Article 10.7.2, compensation shall, is a separate provision which is amenable to breach, or whether it is simply an articulation of the standard set out in 10.7.1c.
I have all sorts of people helping me here, but I actually think I knew the answer anyway, but I'm glad that I'm being held accountable. So the short answer, and I think I'll be formal about it, is we do rest on and leave with you our submissions in the memorial, and to be explicit about it, that properly construed, paragraph 2 is a separate obligation and is not simply a definition of the obligation under paragraph 1. Having said that, and I won't repeat I do commend to you the reasoning in that, and that there is a reason and a purpose and in our submission under the Vienna Convention and otherwise a logic to not rendering that provision inutile and to actually giving it a separate life if necessary. Having said that, as you probably have observed, it's not necessary for our submissions for you to conclude that, because in our fundamental submission, it's a necessary part of the obligations under the first paragraph, that the obligation to compensate in terms of its timeliness and its value are separate obligations. And so it's not necessary, but we do make the submission that on this particular treaty, there is a separate provision, and that supports the separateness, if you will, of the obligation. So I think I'm at the third question, and the answer to that is, on the terms of the treaty, it's the claimant's knowledge of the breach arising from CAFTA that's spoken of, so it is contingent on the existence of a right under CAFTA. Put another way, the claimant's knowledge of the alleged breach is contingent upon the existence of a right under CAFTA. Now, let me say this, and that is we acknowledge that the right spoken of is the right in investor-state treaties, where in a sense the right vests in the state, and the means of enforcing that right has been opened to the investors. So we're mindful of that, but that doesn't change the answer to that question in respect of the interpretation of the treaty.
I think, Mr. Coper, the sense behind the question was trying to identify whether the entry into force of the CAFTA on the 1st of January 2009 for these purposes, to use the word that you've already identified we should be cautious of, sort of crystallizes the breach. So in other words, let's take the hypothetical, and I think counsel for the respondent in his submissions speculated about an expropriation that may have happened 30 years ago. If an expropriation happened in the 1970s, and then all of a sudden the CAFTA enters into force on the 1st of January 2009, the only possible breach of the CAFTA that could have arisen would be on the 1st of January 2009. So I'm looking at the language here of Article 1018(1). No claim may be submitted to arbitration under this section if more than 3 years have elapsed from the date on which the claimant first acquired or should have first acquired knowledge of the breach. And the issue of knowledge of the breach, I think, is, at least in my mind, intended to try and elicit from you some clarification of whether knowledge of the breach is the factual circumstances relating to the breach or the cause of action associated with the CAFTA entering into force.
Yes, and we say it's the latter, not the former. Now, to be clear, we have not claimed that CAFTA permits us to claim for the delay associated with the pre-treaty period. So we do acknowledge that. I think let me try to say a couple of things. In response to my friend's example, if a expropriation has been completed and it is completed before the treaty period, then that's fine. I think you have to define completed. And you obviously have to define completed. And if it's a completed expropriation in that title has been transferred, then that is a completed expropriation. There may be all sorts of problems with it, but it is, factually completed. There may be breaches associated with it, but it's completed. If it's an ongoing expropriatory process, then it folds into the treaty period. And the state has undertaken promises on the commencement of the treaty period in relation to expropriations which have not been completed. There is no provision in this treaty which says the state's obligations do not extend to ongoing expropriatory processes. That's our fundamental point. And our fundamental point here is that these are ongoing expropriatory processes. And I've made the point already that there are measures taken by the state after the coming into force of the treaty and within the three-year period, which make it clear that there's no basis for the jurisdictional objection.
Let me just clarify again then that I understand something that you've just said. You've said delay in respect of the pre-treaty period does not arise. I'd just like to clarify then the expert evidence yesterday from Claimants' expert was that he took under instructions a May 27th, 2008 period for valuation. Could you just clarify whether that period from 27th of May 2008 to the 1st of January 2009, when the CAFTA entered into force, falls within the scope of your pre-treaty period, as it were, exclusion, or is that simply a sort of evaluation methodology, if you like, if one can distinguish between the two?
So there are two separate questions, of course: the appropriate method of compensation and the question of determination of delay. And perhaps take my friend's example and twist it a little bit and say that you don't have a completed expropriation. What you have is an expropriation which has been running as an open sore for an extended period of time, hasn't been resolved by title or otherwise. The treaty comes into force and the state, discharging its obligation, immediately pays the fair market value on the commencement of the treaty period. There is a compelling force to say at that point that the state is not in violation of its obligations under the treaty. In respect of the present circumstance, and as I say, I'll stand to be corrected, but the valuation date we've taken is related to the predicate fact of when would you properly date the assessment of compensation for the property. we also say, in respect of interest, and I mean, I'm sure I'm right on this, but having not gotten much sleep last night, let me just. So your question caused me to wonder whether I was getting it right, but I am getting it right. That we not claimed interest until the commencement of the treaty period. So there's the question of how do you determine the value, and then that's the question of evaluation date, which depends upon predicate facts and likewise. And in respect of an indirect expropriation, it's we say appropriate to say, well, in these facts, appropriate to use that valuation date for those purposes. In respect of the assessment of the state's discharge of its obligations, in a sense, and I don't want to be misleading by grabbing a phrase, but the state has a fresh undertaking on the commencement of the treaty, and it can discharge those fresh undertakings. We acknowledge that, and so it would be quite reasonable to expect a state to say, we're going to review ongoing controversies and ongoing disputes to resolve them, because we've now undertaken to make those promises not just as a matter of domestic legal requirements, but also assurances to foreign investors who've made investments in the host state, and they now have that right to do that. So in terms of determining whether there's been undue delay, we say that the predicate facts of what delays occurred before, the state's not accountable for, but in determining whether the delay is undue, those are predicate facts which are relevant to that determination.
But you've just said that you're not claiming interest in respect to the period before
That's
the
correct.
1st of January, but you are, in terms of your valuation for damages, you are claiming damages that go back before that period. I'm not asking you to address this now because I know that Ms. Cohen's going to be addressing the issue of damages. So if you would like to defer a response to this to her, please feel free to do so. But I'm just seeing a little bit of, at least maybe it's not an inconsistency, but a lack of clarity in my own mind. If you are not claiming interest in the pre-1st of January 2009 period, but you are claiming damages in respect of that period.
So first of all, let me repeat my answer, but then maybe, because it's a very, very important point. But I may spin out a little bit on the thing, and I'm quite happy to deal with it. I don't have to defer to Ms. Cohen, or I can be corrected by her, but I don't have to defer to her. So the question of your award has different components to it. If the state is accountable purely and simply for the payment of an award which is responsive to its obligations under the treaty, those components will include of necessity, whether it's a breach of the expropriation provision or a breach of the delay provision or the breach of the valuation provision. Of necessity, you have to determine what, if you will, that principal amount should have been. Because the delay clearly arises in the treaty period and in the period within the treaty, it's actionable. You have jurisdiction over it. The award would be incomplete. I mean, let me posit two examples. So, for example, if you were to say, oh, well, the interest attributable is only X dollars, so you get $10,000, you don't get the principal, then, of course, that would be an incomplete award because it's of necessity that what's been delayed is the payment of the fair market value. In determining the fair market value, in principle, you must determine the fair market value by reference to the taking. And that event may occur before the treaty because you're determining as a matter of fact what the appropriate valuation is. The treaty doesn't require you to value it during the treaty period. And let me give you a perfect example of this, I think, as a case example. Assume that 10 years earlier, the state had determined that it owed $10 million to the claimants in respect to their properties pursuant to an expropriation, which was not complete. But they had determined the value, they had undertaken to pay, but they had not paid. And then 10 years later, the treaty comes into force, and then 5 years later, payment has not yet been received. In my submission, the award would be you have breached your undertaking to pay without delay, you've not acted promptly, whether you regard the 5 years as the only period or you regard the entire 15-year period, and the award of necessity would be the amount of the fair market value that's 15 years in the past on that scenario. So in this case, the fact that it's a couple of years before is indifferent to the analysis.
Thank you.
I'm not indifferent to the analysis, but the fact is indifferent to the analysis. So the fifth question that you asked is the date on which knowledge the alleged breach could first have been acquired. If that is 1st of January 2009, what impact does it have on the operation of the 3-year limitation period in this case? Now, of course, our point, of course, is that with respect to the handful of cases in which a final determination was rendered after 10th of January 2010, so to remind you that there are values determined clearly within the 3-year period. So in our analysis, it's impossible to have known that those would be in breach of the fair market value standard any earlier than that. And I'm not dealing with a scenario where the state has completely rejected any fair market value analysis. That's a different case, right? Because in our case, the state assumed a fair market value analysis based on the evidence. It, in our submission, simply didn't discharge it. But you can't know of that failure to discharge on those facts until then. A different scenario, it could be in a circumstance where the state has clearly told the claimant it's not going to receive fair market value, that a different analysis might apply. But in the present analysis, that's the answer to that question. With respect to the other lots, the ones which haven't had been paid, then the two objections, of course, remain distinct and come back to the self-standing nature of the obligations under the treaty. And in my respectful submission, that occurred within the 3-year period. And so it's not focused on when the conduct would be construed as a measure, but on when the investor first knew or should have known that the breach had occurred. And so those fall within that 3-year period. And I put emphasis in that context on the more recent events and steps taken by the state.
Thank you.
Okay. The next, I'd like to proceed, if I can, to answer Arbitrator Cantor's questions and answers. I may have foreshadowed some of this in my submission, so I won't, I'll try not to intentionally repeat them, although that's not necessarily a guarantee of performance on my part. But with respect to the first one, I think you have now, as opposed to when you handed up, a pretty full understanding of what was done by the Contraloria and by SINAC and MINE and WEN. But let me just summarize it for the purpose of giving you a formal answer, which is I've already said to you that in our submission, what the Contraloria did was to advocate a brief submission for the purpose of deciding whether or not to suspend. What the agency has done is to have decided to suspend indefinitely, and it seems pretty clear that there's a series of decisions on that point that occur afterwards, but whether it's a series or otherwise, that is the agency decision, and that's what we know. We know for sure that SINAC suspended the proceedings, and I'll just give you a couple of references to that. Loa Sigia, Witness Statement 2, Paragraph 4, and Mr. Urado's transcript on day 1 is 602 to 603, lines 21 to 22. Sorry, you were about to ask me a question, I think.
The word when
Yes.
is a very important part of that question. You can give me claimant's perspective on when those events occurred.
So the decision to suspend based upon their reception of the Contraloria report can occur no earlier than May of 2010, and our submission on a balance of probabilities occurred then and some point thereafter.
Why do you say May when the report was February?
Because the decision that is at issue is not the report's decision, but the agency's response to the decision.
And where in the record do you direct me for May?
Sorry, for...
May as the...
Oh, okay, I can do that. It's, and I may, well, the actual expression Mr. Jurado used, there's two deadlines, and it's, I think, 4.1b and 4.1c in the chronology of compliance. And I can actually take you to those, but let me... It's section 2.1.1. I think you know the sections I'm talking about is 4.1b and c, and one is a reference to April, one's a reference to May. But let me be clear that that's the report, that's not the decision. And in fact, it's simply an advisory to the agency, and what we know is the agency took that, and we know that there was a suspension before the report was delivered, and we know that there's a suspension or suspensions afterwards, a continuity of suspensions. And we also know, for the purposes of jurisdiction, that the claimants didn't know of those suspensions. So in terms of knowledge, it occurred during the course of the proceedings and clearly falls within the 3-year period.
For hypothetical purposes, assuming those suspensions might be legally significant acts, to what would you direct me in the record to understand when claimants should have first acquired knowledge, as distinct from when they actually acquired knowledge?
Okay, I'll take that under advisement, but I don't at the moment know of any clear evidence in the record that they had the means of obtaining knowledge of that decision. They know that no steps being taken, but they don't have the means of acquiring the knowledge that there has been a fresh decision by the agency to suspend activities or to suspend expropriatory proceedings after the contrary report has been expressed. And the difference on the evidence, if you understand, between the claimant and respondent on this is, on my reading of the record, the respondent's submission to you, which was the contrary report, was the decision which suspended the proceedings. I say that's not so on the record, and that was conceded, I say, not to be so in cross-examination by Mr. Jurado. And the one point of detail, so that you'll get the transcript, the one point of detail, prior to the hearing, there was some suggestion that there was, if you will, an act of suspension prior to the receipt of the report in anticipation of the report. It doesn't matter for our purposes, but I'm not sure that that's actually supported on the history here. But what is clearly the case is that the agency decided to suspend independently of the recommendations of the report. Sometime, and that's why I say it occurred sometime after the deadline of, if you will, referral, because has to have occurred after that point. May have occurred before and after that point, but it has to, in an operative sense, occurred afterwards. And for our purposes, there's no means by which that could have been known earlier than the 3-year period under the treaty. That's my submission.
Does that submission relate only to the matters in administrative proceeding or also to the matters in judicial proceeding?
I've given you the submissions earlier on the slide with respect to the right analysis on the judicial proceedings, so I largely rest on those. I think on the whole of the evidence, the evidence of the agency is that they did not purport to suspend those matters that are within the judicial proceedings. I think it is a fair conclusion from Ms. Chavez's evidence and the evidence we put in the record that there were efforts to delay the judicial proceedings by the actions of other government actors. They are restricted in terms of they don't have the same direct chain effect, but we do say that you can conclude in fairness that the state sought to delay the judicial proceedings as and when it could as well. I may come back to that when I have some supplemental, but by the way, before I forget, Arbitrator Cantor, and you've demonstrated a passion for the detail here, there is another typo that you ought to be aware of, that you pointed out a typo, but in the compliance report, and my friends can say whether they agree with this or not, but in the English and I believe also the Spanish transcription, 4.1c, that recommendation actually should read Sector 4, which is a sector within which some of our complainants rest, rather than Sector 6. Now, we have the general admission that it included all the complainants' properties, but that's a typo.
Just to be clear, you're identifying a typo in the comparison chart, the chart of
yes, the
completed
comparison.
actions.
Yes.
Thank you.
Yeah, thank you. The other point that Dr. Weiler referred me to, which is in relation to the Contraloria report, there's a reference to 221, but it's actually 211. So when you go, and I think you can sort that out yourself, but those are two navigation problems between the two documents which we identify. Can I go to question 2? With respect to the question 2, Mr. Cantor, the question was, if the matters resulted in continuation or establishment of a suspension, is there evidence of the expected duration? And I think I've already spoken of this, but just formally in answer to your question, I understand the current situation to be that the suspension is contingent or related to the consideration of annulment on Mr. Hirato's evidence, and that the current situation is that there's a third party who is conducting an analysis of that has not yet been received. In respect of the critical question, which is the duration, by connecting those two, Mr. Hirato said he could not assure the tribunal of when that report would be received, and then that would not, as I said earlier, not be the end of the process, even if it would be the beginning of that process. And so that's the evidence you have about if you will, the expected duration. With respect to question 3, the impact of the matter, because those measures did not commence until after the treaty period, you have jurisdiction ratione temporis to consider the claims, and because the claimant's knowledge of them arose clearly, we say, within the 3-year period, and the capacity to know them arose at the earliest within the 3-year period, there is no time bar under the treaty applicable to those matters. With respect to the 4th question, whether there's a differential impact between the direct expropriation claims and the indirect expropriation claims, the claims for indirect expropriation, just to be clear, logically apply to every lot which has not yet passed from the claimants to the host state, based on our definition of expropriation. And so even those lots that have been subject to measures of direct expropriation have also been subject to indirect expropriation. So that population may contain lots you hadn't thought of as indirect subject matters of indirect expropriation. So in our submission, the only exceptions are those lots in which title's already been passed to Costa Rica, which are clearly within the 3-year period. Now, with respect to the new measures, I've already acknowledged to you that the suspension on its terms on the evidence as a whole essentially applies to the lots that are not in the judicial process. Now, the fifth question is the distinguishment between, or how do you distinguish between so-called measures and so-called lingering effects, and what evidence is relevant to determine the category in which this matter should be placed. Now, we rest our primary answer to this that we actually don't agree with the lingering effects theory, if you will, as it applies to the facts of this case. There may be, and there are lots of cases where you can imagine a completed wrong that has lingering effects. We say that's not the applicable analysis here for the reasons we've already fully briefed and pleaded and referred to the opening. If you, of course, disagree with that and you say, how would you distinguish between the lingering effects, assuming that you're wrong about lingering effects? There's a certain effort of imagination that I have to undergo to do that, but let me try to be of assistance, and I think that's why you asked me the question, so let me do my best. In essence, I think, I would commend to you this analysis, which is, has the state taken measures in the general sense which either renew its determination or express its determination in different ways than simply omitting to act? In other words, if there are, if you will, positive decisions to either not act, which is effectively an omission, but by reason of state responsibility, it's a state action to decide not to act in the evidence, or if you have, if you will, evidence of positive decisions to prolong, in this context, the delay, then those are matters which are not lingering effects. And maybe I could give you a couple of examples which might be of assistance. If a state had under its domestic legal order all that we would hope for, and in a given case had done the right and proper thing of noticing an expropriation and moving to expropriate, and it had under its domestic legal order an obligation to compensate for fair market value, and some later period in time it acted so as to deprive the property owner of that fair market value. That, in my submission, would not be a lingering effect of the original expropriation, but would be a, if you will, a measure and not a lingering effect. On the facts of this case, and I'll just state the obvious, we commend to you that the history of delay here is not a history of, if you will, a lingering odor of something that's happening, in which you could characterize the history, as my friend did, of the train leaving years ago and no other activity on the rails. To the contrary, we say in this case you have abundant evidence of a series of decisions by the state to either, if you will, bring about a new delay, or to prolong an existing delay, or to potentially engineer an unforeseen possibility of another delay. And in those circumstances, I'm just trying to be helpful to you, because I think to some degree we're in sort of unplowed territory here. That's the best means I can provide in principle of distinguishing between what I understand to be the proposition of lingering effects and new measures.
Well, not my proposition, of course. I'm merely quoting back language that
I
we've heard from
understand.
counsel on both
Yes,
sides.
I wasn't suggesting the contrary, sorry. Yeah.
In your response, one of the phrases you just used, and here again I am quoting back what counsel just provided, use the phrase, quote, acted so as to delay, unquote. Without suggesting that this time period is the legally operative time period, we are all well aware of a 3-year period that would commence in June 2010, because in June 2013, the notice of arbitration is filed. Can you identify for me claimant's position for conduct of the state that falls within the phrase acted so as to delay from and after the time period that commences 3 years prior to the filing of notice of the arbitration?
Well, I think the fundamental answer to that are my submissions arising out of the agency's response to the Contraloria report. And I'll come back maybe at the end and give you the color version of that, but that's the fundamental answer to that question. My point in a concept for you, Mr. Cantor, is that in relation to a concern over undue delay, there are delays of different characters, if you will, if you're going to adopt this analysis. And since we're dealing with state responsibility for state action, an action to prolong a delay is as much an action as an action to start a delay, in my submission. And so the ongoing nature of these suspensions, the ongoing nature and consideration of the agency, in my view, extends to the current time. And for that reason, that's my submission in relation to it.
Just to be clear,
Yeah.
is it claimant's position that once a delay commences or a suspension commences, every day thereafter is conduct to continue that suspension, which is independently capable of being considered for purposes of the 3-year period?
I'll give you an answer, and then I'll tell you if I have to nuance it later. But I think you're combining two submissions there in the question. With respect to the first point, it's our general submission that a delay represents an ongoing breach after the reasonable period of time has lapsed, and that's a proper application of the facts and the law to this case, whether or not the state decides to do anything. Okay? That's our primary submission. If you find, contrary to that that's wrong on these facts, and that in order for the claimants to succeed, they have to attach themselves to new decisions, the next point I make is those decisions don't have to be different in character. They don't have to be relying on a different law or a different basis. All that you have to establish is that the state has actively sought to delay in order to avoid, if you will, the definition of lingering effects. And in my submission, the state's actions after and more recently and up until the present time represent that type of ongoing, if you will, decisions to delay. You can characterize them as prolonging the delay which has existed, or renewing the delay, or extending the delay, but I think that's not of any great moment.
Mr. West would like to, I think, come in on this point as well.
Thank you very much. It's on the same line to see if I can understand your point. You mentioned you distinguish new delays from continuing delays. Could you explore a little bit more on that, the difference that you see? Even with examples through different measures, which will be new delays as opposed to a continuing delay.
I think the way I was intending to describe it is that in relation to a period of delay, there may be different government measures which have brought about the total delay. So if you accept the rationing, and I'm doing this under the premise that I accept arguendo, the lingering effects principle, then in my submission, decisions which are in the historical period and which distinctly represents the state's decision to continue or prolong the delay represent measures which are in relation to the delay and which are, if, to use your phrase, new measures. So they don't have to be, and my point that I was saying, Mr. Vinuesa, if we try to bring it in this case as an example, the fact that the decision was anchored on the Contraloria report or independently means that you've made a fresh decision. There's a fresh measure by the state to continue the delay. And so if that decision hadn't been made, then the state would have proceeded and not prolonged the delay. And so what's remarkable in this context on behalf of the claimants is that we have the treaty obligations arise, and that's actually a month and a half later, the Contraloria report basically recommending a short-term suspension, but the state acting to engineer, with respect, an indefinite suspension, which has been continued and which is lacking transparency in that we don't know what it's based on other than a determination and a decision to continue that suspension. So I could perhaps say this, just to give you sort of the anatomy of potential cases, is you can imagine a situation where, under the domestic law, there's a timeline for each of these matters. And under the normal course, you would have a determination of value, a taking, in the sense of an announcement of a future taking, a determination of value and a payment date. And you can then imagine a scenario, which is not uncommon, that the person responsible for that process, the eve before the payment is due, decides to defer the payment. That's a state decision. That's a state measure, which results in a delay. When you come back in hindsight, you may be years later looking at it, and you sit there and say, well, is that a delay associated with the first measure? No, it isn't. If you're distinguishing lingering effects and other measures, that's a new measure. So in the evidence you have here, we know that the agents of the government, in the respectful sense, the officers of the government, made a fresh decision arising out of the Contraloria report. We've talked about what you should conclude the basis of that decision was, but that was clearly a fresh decision, and it's not clear to all those. It's a fresh decision that was unknown to the claimants.
Mr. Cooper, sorry to dwell on this. It's obviously a point that's, you can tell, it's exercising us all a little bit. I'd just like to follow on this point with one more question, at least from me, and to ask you whether you think that it's at all useful to think of it in these terms, and if it is, what the consequences of thinking of it in these terms is. Trying to differentiate between a single dispute of a composite nature, but which has a series of acts, or thinking of it as separate disputes. So, for example, if we look at the time bar period, a dispute that arose in respect of an expropriation, and then a dispute that arose in respect of delay. So it'd be useful to hear from you whether you think that what we are concerned with is a single dispute that has an antecedent period and a more recent period, or whether they are separate disputes. And if you think that if you characterize it as a single dispute, it would be useful to have your views in a rather focused fashion on the language of Article 10.1.3. For greater certainty, this chapter does not bind any party in relation to any act or fact before the date of entry into force of this agreement. And the question that follows from that is, to what extent are we then taken into a sort of a terrain of artificiality, where we are looking, to pre-1st of January 2009 acts or facts, but in order to inform a post-1st of January 2009 as a word, determination, but in circumstances in which this may preclude us from doing so.
I may want to return to this at the end of the hour. I'm just trying to answer your question about whether it's useful or not, and
Let me perhaps just sort of elaborate a small point. I mean, there is, not in the context of these kinds of disputes, at least insofar as I'm aware, but there is case law out there which suggests that there may be a measure of artificiality in trying to pass up a composite dispute into different composite parts, because it doesn't allow a tribunal or a court to actually get to grips with the whole of the dispute. So that's the point that I'm trying to grapple with.
Well, I think the answer I would give you, and I don't know whether I'm using your language or my own language, but is that the dispute that the claimants bring you here is that they have not received the discharge of the promise under the treaty within the treaty period. And in order to determine whether that dispute is proven, you have to decide whether the incidents of that dispute have been made out. That may require you to have regard to precedent facts, but it most definitely does not, in principle, require you to retroactively apply the treaty. And maybe I'll give the perfect, I think what is a very clear example is, and maybe we'll give two examples from the present case. If you assume for the moment that there has been an announcement of a taking, a public purpose, a fair market value, and then a unconscionable delay within the treaty period for payment of that fair market value, that dispute is one over which you have jurisdiction. You must assess whether or not the delay has breached the provisions of the treaty during the treaty period. And I say, in terms of artificiality, it would be entirely artificial to disregard the delay before the treaty period in determining whether it's conscionable or not. But it isn't governing. And in the facts of this case, we say the delays are sufficient even if you disregarded the previous delays. And in connection with that, then, you are honoring the treaty period, you're honoring the state's undertaking, and you're acting on matters which are at the heart of your jurisdiction. You're not reaching back in any material way. In order to discharge and to make an award in that circumstance, it requires you to determine what value it should have been. Otherwise, otherwise you can't restore the party and provide restitution for breach of the obligation, because wrapped into the delay is what they failed to receive.
Thank you. Sorry to delay you on this question.
And if I could, Mr. Cowper, trying to continue to understand as it relates to the 3-year time period. My chair has been inquiring there about the start date for CAFTA, but the 10-18 3-year time period. You noted that I am detail-oriented. I would like some specific fact details, assuming hypothetically and without deciding that your proposed language from what you've just said acted so as to delay, or state decisions were the legally operative tests. The notice of arbitration here is June 10, 2013. Working backwards, that means June 10, 2010 is a date that has legal significance in some form or another. You've mentioned that the response to the Contraloria report had to have occurred no earlier than May 2010, but May, of course, predates June. Mm-hmm. Can you identify which specific decisions or acts your client relies upon that arose from and after June 10, 2010?
Well, I think what I need to do is I think I've answered that, but I'll come back at the end and answer it more specifically. But what I say you ought to be able to readily conclude on a balance of probabilities is that the decisions that were made in relation to the Contralory report occurred after May. Okay? Now, the record doesn't permit you to pin it to a date, but of course the two operative legal questions are what was known by the claimants. Right? So if, let's assume for the moment you have an ought to know standard, in order for us to succeed, all we have to do on an ought to know standard is to say we couldn't or ought not to have known until the 10th of June 2010 that that's what had happened. And we of course say we couldn't have known until, in fact, the pleadings were received, but that brings it way past 2010. So our primary position is that the knowledge spoken of under 1018 occurred during the course of these proceedings.
Thank you for your patience. Please proceed now.
I just for the sake of completeness, and I know Ms. Cohen is champing at the bit to take the podium from me. I can answer 6, 7, 8 pretty quickly, I think, and I think you probably know what the answers are. We say that essentially what we've been speaking of falls within the bounds of our statement of claim, and you'll have regard to 67 as an example of the notice of arbitration, which speaks of a policy of refraining, commencing, or otherwise completing steps necessary for delay. So refusing the grant. So I think it fits within the existing pleadings. With respect to, it's not a new claim for which a statement of claim is required, but out of an abundance of caution, on October 4th, we said if it was, we sought leave to amend, given that it had been disclosed in the context of this proceeding. In terms of how you should treat it, of course, it's Article 22 of the relevant UNCT trial rules, and if you consider it to require an amendment, we say we don't require an amendment. We say you ought to, in the circumstances, grant that amendment. I think I'll do you want to do, Dr. Weiler promises to do Chapter 17 in under 30 seconds.
Clock's ticking, 30 seconds.
You asked about Chapter 17. The important thing to note is that Article 10.2.1 provides, quote, in the event of any inconsistency between this chapter and another chapter, the other chapter shall prevail to the extent of the inconsistency. We don't have an inconsistency. So really, Chapter 17 is not going to apply directly. Though I would say that you might want to look at Chapter 17 within the context of the Vienna Convention, Article 31.3 context arm, because there are some interesting provisions there which would suggest that, again, that there are some procedural problems with regard to the delays in this case. I would direct your attention to Article 17.6, opportunity for public participation. And I would also direct your attention to Article 17.9, environmental cooperation.
I'll give the podium to Ms. Cohen now.
Thank you, and I'll just mention, as she's presumably you're going to swap seats, or she looks. And I'll just say for your ease as you start that I'm not proposing to cut the microphone off at 12:30. The tribunal's delayed counsel with a number of questions, so we will.
And just to be clear, that was a distinct act of delay. It was
well,
not.
That's a matter that we'll have to decide upon. As long as it's not lingering effects. Ms. Cohen, over to you.
So I think some of the comments.
Should we just wait until this has been given to the
My
interpreters?
apologies.
Okay.
Some of the submissions that I was going to make, I think, have been covered, so I will try and stay as close to the 12:30 mark as I am able to. With respect to damages, first, the next slide, just an overview of the reports and the different methodologies that have been applied here. In my submission, the only appraisal of the subject lots before the tribunal is the appraisal that was provided by Mr. Hedden. And in my submission, he is a qualified appraiser who has followed the appropriate methodologies in coming up with the proper values for the subject lots that are before you. Just turning to the next slide. I think the tribunal is by now very familiar with the fact that the fair market value is the appropriate measure for compensation. The comparables that were used to determine the fair market values in my submission are reasonable. While they were not comparables that are as perhaps easily available in other markets, the comparables that were chosen do reflect in my submission what are appropriate values when adjusted in accordance with the methodology that was applied by Mr. Hedden. For the V lots, the comparables used, and I've listed the three comparables, were all located within the 75-meter zone, beyond the 50-meter inalienable zone, and the sales prices for those lots would reflect any lawful and non-expropriatory measures or actions of the Republic. So I think that covers the question that was being addressed yesterday. The next slide, the sales prices for the lots are consistent with what would be expected upon a considered and supported market analysis in my submission. And I've set out the references in Mr. Hedden's report where he analyzes the market in the real estate market in Costa Rica and why it is not in my submission correlative to the US market. In my submission, the extreme boom in the real estate market in Costa Rica was not comparable to many other markets. It was substantial increases in value over the period of time from 2003 right through to 2007. And those extreme increases in value are reflected in the purchase prices that you see both in the comparables and in the values that we are submitting as being the appropriate values for compensation. Turning to the next slide, I say that this is particularly so when we look at the subject lots, which are, in this case, lots that were in the prime area. They were unique in the sense not only that they were in beachfront lots, but also in that they were fee simple lots, which is unusual in the area. I refer in these slides to the market timing, and I have given references in the slides, and so I will leave that with the tribunal. But there are a number of references in the record which clearly indicate in my submission that the market did not peak and then decline in 2006, but rather it continued to increase in value right through 2007. And it was only in 2008 where it tapered off and we see no further significant increases in value, but it held its value for a period of time. And at the earliest, I say, the decline in value happened in the fall of 2008. I've included a graph that shows the market timing. I don't intend to spend any time on that. Turning next to the reports of Mr. Kaczmarek. In my submission, it is clear from the scope of work when one reads Mr. Kaczmarek's first report that he was not asked, nor did he do an appraisal or any formal methodology applied in valuing the properties that are an issue in this proceeding. The Mr. Kazmarek is not qualified to do so. He's not a certified or licensed appraiser, and he did not prepare his report in conformity with any of the applicable appraisal standards. Turning to the next slide. In my submission, Mr. Kazmarek was a partial witness whose presentation, in my respectful submission, sounded more like closing submissions of legal counsel. He engaged in a fact-finding mission. He reviewed witness statements and came to his own conclusions on facts and legal analysis in respect of the very constitutional court decisions and park law, which are an issue in this proceeding. I've given a number of examples in his report in my submission, which I say are evident of that in my submission. His presentation and his answers to questions in this proceeding are also evident of that. I say many of his conclusions go to the ultimate issues which are within the purview of the tribunal. Turning to the next slide, I say, again, still referring to Mr. Kazmarek's reports, that he did not identify the source of many of the statements contained in his report, and there's no evidence that he did any independent verification beyond reviewing some articles that he's attached to his report. I say the articles that he has attached do not support the conclusions that he reaches, and in any event, they're not sufficient for this tribunal to draw conclusions about the market timing in Costa Rica, and in particular, the areas of Playa Grande and Playa Ventanas. He acknowledged that his findings of fact, are, if they are not concurred in by the tribunal, may influence the outcome of his opinions. Turning to a couple of specific examples of credibility, and I apologize for the number of words on this particular slide, but in my submission, Mr. Kazmarek was guided with a view to an objective, which was to compensate the claimants for the lowest possible amount, using the facts to try and manipulate that outcome in my submission. And two examples that I have included in my presentation, in my submissions to you this afternoon, are firstly his conclusions or his opinions with respect to the appraisal, the administrative appraisals that were rendered with respect to these subject lots. It was clear in his cross-examination yesterday that although in his reports he states that in his opinion the administrative appraisals were reasonable, he did nothing to actually verify either the methodology that were used by the appraisers who came to those administrative appraisals. He did no analysis of the comparables that they used to see if they were at all relevant to the subject lots. He did no analysis of the valuation dates that were chosen by those appraisers, nor did he do anything else to verify whether those reports have any bearing on the fair market value of the subject lots. And in my submission, it's clear on the face of the administrative appraisals and the amounts that they've used that they are not at all reflective of fair market value. And that is further confirmed by the fact that in the judicial process, a number of the administrative appraisals were substantially increased as a result of the judicial process. And I say even those judicial appraisals did not result in a fair market value for the claimant's properties. I say his own, the second example that I give is with respect to his conclusions with respect to fair market value in his own report. And you'll recall yesterday the cross-examination of his belief with respect to the B lots and whether they could possibly have actually had a purchase price of $200 per lot. And in my submission, based on the information that he had at hand, including the document that he relied upon from the registry, which showed that there were mortgages on the 1B1 lot that were in excess of $400,000, he could not, in exercising any professional judgment, have possibly concluded that the actual purchase price was $1,200. And I will come back to that point because it's relevant to the basis upon which the tribunal decides to award compensation. Turning to the next slide, I refer again to the submission that I was just making. So passing over that slide on to the next slide. So with respect to the amount of compensation, and I haven't included the amount in the slides, the amount is found in Mr. Hedden's presentation, and the amount claimed is $36,608,000 US. That is the amount that takes into account the severance damages as well. And I should say, so that I don't forget to when I come later into the slides, that the preference of the claimants would actually be that the state take the entirety of those lots and not leave any remnant or remainder at all. And if one were to award compensation on that basis, the amount of compensation would be the amount that's indicated in Mr. Hedden's report as the before taking value for those properties. So just to be clear, we have valued the lots that were taken, and the portion of the lot that was taken, and then included in Mr. Hedden's report is the severance damages. But the preference, and it is within the jurisdiction of the tribunal to award the claimants and require the Republic of Costa Rica to expropriate the entirety of those lots and not to leave the remnant behind. With respect to the treaty guarantee of restitution in relation to value immediately prior to the taking, in my submission, that requires the payment of full fair market value. It's tied to the concept of fair market value. It's not tied to the cost or the price that was paid by the particular individual who happens to be holding the lot at the time of the taking. It is tied to the fair market value at the time of expropriation. And just while I have it in mind, I would refer you to, in the memorials, my apologies. Finding the right binder. I would refer you in the memorials with respect to that point to page 95 of the claimant's memorial on the merits. And in particular, in the SEDCO case and National Iranian Oil Company, the tribunal there concludes that the tribunal must not consider as an element of value the taking itself, nor events preceding the taking calculated to diminish the value of the property. And again, in Compañía del Desarrollo de Santa Elena, which I'm sure the Republic of Costa Rica is well aware of because that was a decision in which Costa Rica was also involved. The tribunal there determined that the date of expropriation for valuation is important because there is no evidence that its value at that date was adversely affected by any prior belief or knowledge that it was about to be expropriated. And so that the concept that the regulatory action, expropriatory action, or unlawful conduct ought not to be taken into account in respect of the values is very much a principle that has been applied in international law commonly and appropriately.
Can I just make sure that we've got the right reference? It's page 95 of your first memorial.
Yes, it is, and it's in the footnote 251.
I don't have a footnote 251 on that page.
Page 96.
96, is it?
Oh.
The footnote beginning SEDCO against National Iranian Oil Company.
That's correct. I apologize. For some reason, mine is page 95. And in my submission, there is a distinction between the date upon which the valuation date that's chosen and the date for calculation of interest. And that is because of the statutory requirement that the date of value is the date immediately affected by the expropriation, so that it doesn't take into account the expropriatory measures or unlawful regulatory conduct in thereby diminishing the restitution that is given to the claimants, whereas the compensation of interest is tied to the date of breach. So the breach occurs. That doesn't mean one doesn't look back in time to assess when to measure the appropriate compensation. But in terms of the interest and international law relating to the requirement to pay interest, it is calculated from the date of the actual breach, which in this case would be the date of the delay, which is after the CAFTA was in effect. So I may come back to that when I get to interest, but I'm trying to be economical with my time. Still on the slide 62, any award based upon a return of the purchase price would have to ensure that the genesis for the analysis, or the proxy for the analysis being the purchase price, is actually reflective of the fair market value at that time. And there are certainly some issues with respect to that in the record, because there is debate about what the appropriate purchase price was at the time. I have handed up a chart that has been prepared, demonstrative evidence that summarizes the evidence and performs an analysis, an alternative measure of damages. And in our submission, this is not the appropriate measure of damage. The appropriate measure of damage is that as quantified by Mr. Hedden. But if one were to adopt an analysis based on the purchase price, in order to ensure appropriate restitution, one would at least have to take into account a proper return on the real estate value, or proper return on value for that taking. And in my submission, up until the time of expropriation, the owner of the property is entitled to the use and enjoyment of that property. And that use and enjoyment includes the increase in value that the property experiences over that time period. And just to give the references, because I did not have time to add the references into this summary chart that I have handed up separately. With respect to lots 40 and 39, the first two, those are taken from Mr. Kazmarek's, the purchase price amount is taken from Mr. Kazmarek's second report on page 17. B7 is taken from Mr. Gramillion's witness statement at paragraph 7. C71 is taken from, sorry, I can't, C71 through to V61C, those purchase price amounts are taken from Mr. Kazmarek's second report on page 17.
Ms. Cohen, I think I can probably save you some time here. You've got all of those noted down rather than trying to sort of read them into the record here.
That's
Why don't
right.
you just sort of annotate that on the basis that all you're going to be doing is putting in the references and provide that to us as soon as possible, unless the respondents would like to have those references in order to be able to prepare their reply.
Mr. President, we anticipate objections because we are wondering where those numbers are coming from, and the sooner we are provided the references, perhaps as early as possible after the beginning of the lunch break, the better, so that we can digest and potentially object in the afternoon.
Digest the references rather than the lunch break.
Absolutely.
Well, Ms. Cohen, if you could do that as quickly as possible after we sort of adjourn now to provide those to the respondents so that they're on notice, I think that'll save time in going through all of these 26 lots.
I would be happy to do so. And so, but just to take you through the chart itself, what it indicates is the property cost and the date of acquisition, the monthly return that is applied over the period and I submit to you that those monthly returns for 2003, 2004, 2005 are conservative, if anything, and I will take you through a number of examples of why that is in a moment. For 2006, 2007, and 2008, the monthly return percentages are those that were determined by Mr. Hedden to be appropriate for the market at those points in time. And then that amount is calculated on the basis of the amount or the square footage of property that was taken to come up with a per square meter compensation amount for those subject lots. And just to explain that with respect to the lots that are at the second portion of the page, the lower portion, the B lots and the SPG lots, with respect to those lots, because the lots were aggregated, they're larger lots, it was difficult to perform this analysis on a purchase price basis. And so for the entirety of the square footage, the unglob, the amount that was awarded in unglob is used as the per square meter value as of January 2006, and then the returns are applied thereafter.
Mr. President, just to register a quick objection, in the closing statement, what we are being provided with is an entirely new damages calculation. We move that this be stricken from the record.
Thank you.
In my submission, it's a pure mathematical calculation. It's demonstrative evidence, which is taken from the evidence that is in the record. It's not the basis upon which the claimants submit the award of damages and compensation ought to be made, but rather is intended to address an alternative methodology for quantification of compensation along the lines that was being questioned yesterday.
We'll reflect on the objection, but notwithstanding, if you could please sort of annotate this with all the references, just to make sure that those are there and the respondent has those if they need to continue.
Yes, I will do so. And just turning to the next slide, I think I have covered most of the comments that I wanted to make on this slide. I do refer to, as I said, in my submission, the amounts are conservative. The transaction with respect to lot V61 in my submission is indicative of the conservativeness of the amount. There were substantial values that were obviously being experienced in that market at the time. Turning to the next slide with respect to severance damages, I don't intend to say much about that other than that the hand-up that I did give you does not take into account severance damages, and so severance damages would have to be added on top of that, or as I indicated earlier, alternatively, if the entirety of the properties is taken, the square footage would have to be increased to reflect the entire square footage of those properties. Turning to the next slide with respect to Article 10.7 of the CAFTA, I have already submitted to you that in my submission, the intention is to ensure full restitution, and that is why the basis of the compensation is fair market value. With respect to the next slide, the respondent suggests that to pay fair market value would result in the claimants receiving a windfall. And in my submission, I would submit to you that in doing otherwise would result in a potential encouragement to states to take unlawful and expropriatory measures and to delay the payment of compensation so as to drive down the price or fair market values of the properties, and then have to pay lesser compensation. It is the very, in my submission, unlawful and expropriatory measures that have created the possibility for speculation in the marketplace, and the respondent should not be rewarded for having taken those measures by awarding them compensation on the base, by awarding compensation to the claimants based on the prices that they paid rather than the fair market value at the time of the taking. I also would refer you to the second memorial, the reply memorial. On the merits, and I direct your attention to paragraphs 259 through 263, through 265. I will not take you through them now, but I think they also address the case law with respect to these issues, which is of assistance to the tribunal. Turning to the next slide, I've addressed already the valuation date. I don't intend to say any more about that. Turning to the UNGLOB decision, the language of the treaty in issue in the UNGLOB case is not the same, and I've noted in paragraph 301 of the UNGLOB decision, which I believe has been given to you electronically, that in that case they quote from the treaty provisions. It is a different basis, it's a different measure of compensation, I think in a material way, and it differs, so I do note that. But with respect to the conclusions of the experts on compensation, I note that they varied widely. The tribunal comments that the claimants sought compensation at a valuation date of July 2006, which they characterized as the peak of demand in the market. The respondent's expert, who was Mr. Kazmarek, advocated for a valuation date of 2003-2004. Just turning to the next slide. The tribunal agreed to a significant degree with the claimant's expert, but concluded that rather than awarding compensation on the peak, they would award compensation on the period 6 months prior to the what was determined to be the peak, and so compensation was awarded as of January 2006. And I note here, based on the math, and this isn't in the slide, so I note it for your reference, at paragraph 299 of the UNGLOB decision, it refers to the values that were contained in the expert reports. And the appraisal dated the July 2006 values for the 75-meter strip at $5,190,000 per square meter, or per meter, or $692 per square meter. The value awarded was $3,100,000 as of January 2006, and so I note that for that 6-month period, the difference in value was a 67% increase in value for the period, for that 6-month period between January 2006 and July 2006 for the UNGLOB property, which in my submission is very comparable to the subject lots in this proceeding, given that it is on the same strip of beachfront. And that would be an 11% per month increase, which is substantially less than the values that are being either included in Mr. Hedden's report or in the chart that I've handed up to you.
Just to be clear, your references to paragraph 299 of the UNGLOB award is to the position as set out by the claimants there, and then following is the position of the respondent. So we'll find it in the award. I'm just not sure that that reference is a correct reference looking at it now.
I'll double check that as well over the lunch break. Turning to the next slide, skipping over to the next slide on, damages, staying on this slide for a moment. I think I've covered most of what I intended to say at this slide, but for one thing, which is that in this case, there is also a claim for damages based on Article 10.5. Given the circumstances of this case, the amount of compensation being sought is the same. There is no difference in compensation But the intention is to put the party in the same position that they would have been in as if the wrongful conduct had not occurred. And in this case, we say the measure of damages is the same, irrespective of which basis of, upon which basis it is awarded. Turning to the next tab on interest, in my submission, the interest that could have been earned if compensation had been paid and invested favorably is the appropriate measure of interest. And just referring to the memorial on the merits, paragraph 322, the principle of full reparation requires that the claimants be awarded interest at a rate that fully compensates for the delay. And in footnote 268, it's noted that pursuant to Article 38, Sub 2, interest runs from the date when the principal sum should have been paid until the date the obligation to pay is fulfilled. And so I refer the tribunal to both of those portions of the memorial. And also commend you to the reply on the merits at paragraphs. Sorry, I just want to double check. So I think it's page 71, but I'll just refer you to the paragraph reference so I ensure that it's the correct paragraph. Paragraphs 259 through to 265. In my submission, compound interest in this case is appropriate as it reflects a commercially reasonable rate. And I noted in the cross-examination yesterday that there are many circumstances in which compound interest is awarded in circumstances where commercial interest is applied, as it has been sought in this case. But the interest that is being sought is a commercially reasonable rate of interest. So subject to any questions that the tribunal may have, I don't, were you going to address costs? Yeah. Mr. Cowper is going to address costs, but those are the only submissions I was going to make on down.
There are one or two questions from the tribunal.
Ms. Cohen, thank you very, very quickly. As you know, the parties are in dispute over whether or not claimants knew or had reason to know prior to purchasing their properties of a risk of expropriation, or as alternatively stated, that the property was, quote, in the park, or there was confusion as to whether the property was in the park. If hypothetically the tribunal were to conclude that the claimants did have reason to know of a risk of expropriation before purchasing the property, in your view, is that a decision that is relevant to the computation of expropriation compensation under CAFTA?
In my submission, it is not relevant to that question.
If it were relevant, do you have a view as to how one would go about taking account of it?
Well, I think that the way that Mr. Hedden has performed his valuation report, it takes into account, it uses comparables that were within the park. And so to the extent that the risk of expropriation was present, it would already be baked in, to use a sort of inartful slang. It would be baked into the prices that were seen with respect to those comparables.
Same question, but with respect to any potential hypothetical finding by the tribunal that Costa Rica's conduct was a breach of the minimum standard of treatment, including fair and equitable treatment, would a finding by the tribunal that claimants knew or had reason to know the property was subject to a risk of expropriation have an impact on calculation of compensation in those circumstances?
In my submission, it would not, because again, the concept requires that the claimants be put in the position they would have been in had the wrongful conduct not occurred.
Last question. I note that the chart you've handed up and are later going to annotate further covers up through the period of 2008. There are some who advocate that in thinking about compensation for a breach of the minimum standard of treatment, including fair and equitable treatment, that the proper date for determining damages in that scenario would be the award date, not the date of a hypothetical expropriation. Would you care to comment on how that might relate to an alternative methodology?
In my submission, what the case law, the arbitration law suggests is that it is the claimant's choice as to whether or not the date applied should be the date of expropriation or the date of the award, and that it is typically the higher date, the higher value that would be awarded. In this case, there is not much, if any, evidence about what the current value of the market would be absent the expropriatory. I mean, it's the conduct makes it very difficult in my submission. The conduct of the state makes it very difficult to now determine what the fair values would be at a present valuation date. But there is some evidence in the record that the market, the real estate market generally in Costa Rica has returned to the value that it would have had in the 2006-2007 period. But the evidence is pretty scant.
In speaking of an option on the part of claimants and case law relating to that for a later date, are you referring to the awards that have drawn distinctions between lawful and unlawful expropriations?
I am, yes.
Is such an option, in your knowledge, also found in awards dealing with a breach of the fair and equitable treatment standard or the minimum standard of treatment, including fair and equitable treatment?
I don't know that. Not to my knowledge, no.
Thank you. No additional questions.
Thank you very much, Mr. President. Ms. Cohen, I have a very general question, just to try to understand the dimension of your work on damages. And it's, if you consider that the only appropriate applicable standards to be applied for real estate appraisals in Costa Rica to determine fair market value conformity with international law should be assumed to be United States of America standards, or United States of America standard as defined by American professional institutions. It seems to me you're relying on a way of thinking that define your standards, or the only standards you apply, as American standards. Even if you call international standards, you do refer to American organizations or professional organizations defining those standards.
In Mr. Hedden's report, he refers to both, or in his analysis, he refers to both the American standards and also the international valuation standards, and he has applied both with respect to the rendering of his opinions, but he is an American expert, and so he has applied the standards that are applicable to him in rendering the report.
And I assume that when he's talking about international standards, refers to the international standards that are applicable for these American institutions.
That are applicable. Sorry, I missed that. Yeah, I don't think with respect to the matters that are in issue in this proceeding that there was any distinction between the international valuation standards and the USPAP.
Okay, I will check that. Thank you.
Mr. Coper, you want some concluding remarks?
Yes. Yes, thank you. And one point that I may offer in response to Mr. Cantor's comments of detail, which Ms. Cohen can strike me if I'm off, but is on the evidence here, to the extent that the claimants purchased on the conclusion that there wasn't a risk associated with expropriation or in the park, that fact renders it a more close proxy for fair market value, just to state that obviously. We stand on the fact that the treaty expressly guarantees that people whose property will be taken will not be visited by a diminution in value associated with the expropriation becoming known earlier. Finally, let me say that with respect to, and I'm only going to be a minute or two, I said I would come back to you with respect to the ought to standard, and I don't know that I said that precisely, so I probably covered it in one of my several answers to you, but the point I sought to make, or I would make, is that if the claimants ought to have known of the Contraria report in February of 2010, and then they're held to have ought to have known of the deadline for the decision by the ministry, that is distinct from holding that they ought to have known of the decision that was made sometime later. And so with respect to the proper operation of the 3-year period, my point was May is not a magic date. It's the date on which they ought to have known that some other measure has intervened, and that date clearly has to be within the 3-year period. We say it's actually through the pleadings, but even if it's not through the pleadings, it has to have occurred after June of 2010. That's my ought to have known answer to you. Finally, with respect to costs, and I'll be very brief on that, the claimants do ask for costs in the normal course and ordinary measure of costs of attorneys' fees. I do want to say that with respect, my friend characterized his claim for costs as attendant upon the frivolous nature of the claimant's claims in this case. In my submission, you ought not to, even if you conclude that these claims are defeated for any of the reasons set out by the respondent. They are clearly not frivolous in any measure, and you ought to consider in exercising your discretion, if the matter is dismissed for any of the reasons offered by the respondent, declining to award the respondent costs, even if there's an unfavorable outcome for the claimants in view of the general circumstances of state action in this case. And those are the submissions for the claimants. Thank you for your patience and the enjoyable morning.
Thank you very much, Mr. Copa. Mr. Alexandrov, we're in your hands now. We were due to break from 12:30 through till 2 o'clock. If you feel you need the extra half an hour or so, we will recommence at 2:30. Otherwise, I think we'd be quite content to recommence at 2 o'clock.
Mr. President, we are content to recommence at 2 o'clock. I want to ask for two clarifications. One is, if we have to go a little bit beyond the time allocated to us, I hope that will be granted the same courtesy that Claimants Council did.
You can take it that you will be granted the same courtesy. I think claimants were delayed because of the questions from the tribunal, and we will certainly grant you the same courtesy.
We hope that there will be questions to us as well. And my second question is, we ask that you repeat your instructions that we be provided with those references as soon as possible.
That's not necessary.
So that we can look at them and be ready at 2 o'clock to address the issue that I raised in the context of my objection.
I think it's in the record. I see Ms. Cohen scribbling away. Claimants will provide you with a copy of those references as soon as possible.
I will switch copies with you in about 2 minutes.
In that case, we are content to start at 2.
Thank you very much. Then we will adjourn until 2 o'clock. Thank you very much.